Welcome to the Goal Podcast, news and commentary from Gun Owners Action League, your leading voice for the Massachusetts gun owner.
I'm Jeff. Across the table is Garrett. To my left, Garrett's right, Mike Harris.
Hey, guys. What's
up, fellas? How are you?
Baby? Good to see you, man.
Director of Public Policy for Gun Owners Action League.
There you go. Look at that.
Yeah, we have about a whole bunch of editing for Garrett to do because
we have a whole bunch of
when Mike got here. So Mike and I both are into bourbons and whiskeys and stuff, and we're kind of trying to drag Garrett kicking and screaming along.
Garrett is a beer guy.
But but we brought a selection. I think we found one that you kind of like.
Yeah,
at least we're narrowing down the vein of like where you like to be.
I am happy with the flavor of the what is that? The Weller 12?
Weller 12.
Yeah, I was gonna say tell him which one he likes.
I'm happy with the flavor of that one, but I don't know if I'm willing to pay.
I wasn't really sure if I was comfortable in the Corolla, but the Cadillac was really nice.
So Jeff brought a small smattering of bottles.
A small smattering.
Yeah, so we brought Michter's Toasted Barrel, a Jack Daniel's Heritage Barrel, the Toasted 100 Proofer.
My favorite.
The Russell's, I got a Russell's 13.
Love
and
Russell's.
Then the Weller 12.
Yeah. So me being not a bourbon guy,
outstanding selection of bottles.
I think they were all like good to varying degrees, but I like the Weller. The Weller with a little bit of ice, I think, does it for me.
Yeah, I mean, it went from like a cross section of like different styles, different finishes.
This was a great
mash bills. Everything has a decent amount of age on it, but
it has subtle notes of leather and earth.
Oh, we weren't doing that. Get out of here.
No.
But no, Jeff. This was. I mean, nothing's perfect, but this was an almost perfect split of like flavor profiles. We were talking about this before we turned the mics on. Like, I am finding that the cheaper bottled in bond varietals, to use a horrible word, I am preferring more than the expensive bottled in bond varieties.
Yeah, I mean, if it's like, listen, do you want good for $20, or versus $100, and
I think
how much better? And
yeah, I think it's more an expectation.
Yeah,
because I'm like, okay, this is what bottled in bond tastes like. Because Evan Williams bottled in bond, it's like $20 for a handle, and it's stupid good. It's better than it has any right to be at that price.
That's all right, ladies and gentlemen. These people will go on for an hour and a half if I let them go on for an hour.
But anyway, all right. Well,
we got an actual podcast to do tonight.
So today we're gonna cover kind of a lot, but it kind of revolves around kind of one, I guess, basic concept. Really, is who exactly counts as the people that are covered under the Second Amendment. So we got a Massachusetts case about adults under 21, Supreme Court case asking whether a 17-year-old nonviolent felony can permanently disarm someone. Another case questioning whether government can categorically disarm people for something as vague as being unlawful user of controlled substances. Meanwhile, Rhode Island lawmakers are scrambling to fix a gun ban they apparently forgot didn't go far enough.
Crazy.
And then back here in Massachusetts, firearms instructors have less than a month to design and get courses approved twice before an emergency law passed 2 years ago finally goes into effect. So we're gonna take one at a time.
I liked that phrasing. That was good.
Once you see the man behind the curtain, one thing becomes clear. It's the great and powerful Oz of gun control.
Yep.
Has zero idea how civil rights or the rules they're writing are supposed to work.
Before we do, let's talk with Mike. Mike, regarding the New England Firearms Advocacy Conference.
Yes. So I am so excited about this. So so when I first started at Goal and I realized that there were all of these state organizations across the entire country, I said, oh my God, we should all talk to each other. Why do we not all talk to each other? And then I realized
there are a lot of really crappy states stuck all together.
No, it's not even just that. It's like, it's one sandbox and we're all fighting over the same toys.
Yeah.
Because there's only a certain amount of funds that can go around to all of the organizations, which is something that you don't really want to think about, but is real. So, New England being a collection of 6 tiny states that all are very close together and smashed into one one area, we all kind of cross over and run into each other. So this last September in 2025, I was at GRPC with Holly Sullivan of CCDL, the Connecticut Citizens Defense League.
She's great.
She's fantastic, and they are a world-class organization. They are
they're doing great work down there.
Fantastic work down there. Especially fighting the stuff that's going on right now with Ned Lamont trying to ban Glocks. They have a hearing tomorrow where they have I think they have 300 people signed up to testify tomorrow.
Unbelievable.
That's insane. I wish we could get those numbers in Massachusetts, but that's another story.
That's a different discussion, yeah.
But anyways, her and I were having a conversation about this, and we both kind of had the same idea where, like, why don't we start a regional conference? So we were, we went to dinner with a few people. Jared Giannis was there and a few other folks that we've been working on that have New England connections. And we said, let's start in New England. There's 6 states all smashed together. Yeah. We all cross each other's borders all the time. We're constantly hearing stories about folks from New Hampshire or Maine or Connecticut being arrested in Massachusetts.
Floating over the wrong border.
Exactly. With a gun in their car that they shouldn't have, quote unquote, shouldn't have had where they had it. And we said, okay, let's see if we can come up with an idea to get everybody in the same room together. So we put together the NEFAC.
NEFAC.
Which is a funny acronym. It's just like Garrett said a few minutes ago. It's the New England Firearms Advocacy Conference.
Not to be confused with the New England First Amendment Coalition.
Yeah, I know, that's a little rough.
There is an existing organization that has that acronym, so you got to.
So speaking, we're not an organization. This is just a conference, and the actual name of the conference is the FAC.
There you go.
So it'll be the firearms, and it will really be the RFAC, the regional firearms advocacy conference.
Oh, there you go. Yeah.
So I think the next one next year is going to be in the southwestern area. Anyways, that being said, this is the first one. We're starting this from scratch. It's a brand new conference that we're setting up. Anybody who couldn't make it to GRPC to see the big speakers that were there and kind of get that information, we're going to be localizing it for folks.
Oh, it's fabulous.
Because everybody has unique, little bit of unique issues, but you can cross-pollinate ideas, share notes.
Right.
And it's coordinating, everybody pulling the sled in the same direction for the general good. But a lot of these things, it's, tons of people have great ideas and it's like, well, somebody should do this. But it takes someone to say, I'm going to do it, and then putting in the legwork to do it, which you and Holly are doing.
Yeah. And we're kind of like the bluest corner of the country. Even though we're kind of a 3-3 kind of
painfully blue armpit of the America.
Exactly. But even though we're kind of, as far as firearms go, we're kind of 3-3 as far as states go. Rhode Island, Massachusetts, and Connecticut are very, very restrictive, but
are pretty terrible.
Yeah, but Vermont, Maine, and New Hampshire tend to be less. Pretty much the opposite.
Yeah.
Vermont just never made any gun laws until 3 years ago. Everybody says, oh, they were the first constitutional carry state. It's like, no, they just never made any gun laws. They're like, oh, the Constitution's cool. Let's just do that. Exactly.
You guys, the New England FAC, have an event coming up.
Yeah,
Let's talk about that.
So May 30th, it's going to be the full day. The morning is going to be dedicated to the 6 states. So we have 6 state level organizations. We are all working together. It's us, CCDL, the Rhode Island Firearms
Rhode Island 2A Coalition.
Yep, coalition.
Us meaning
Goal. When I say us.
Okay.
So when I say us, it's Goal.
That's what I'm saying. Yep. Who's us?
So Gun Owners Action League and CCDL. So it's really me and Holly who are really driving this.
Yeah, it's great.
And we're kind of working with the other organizations in the other 4 states to really drive this.
It's going to be May 30th, all-day event.
All day.
Tickets to the conference are $25.
Yep.
It includes a 1-year membership to CCRKBA, so that's Citizens Coalition for the
Committee
for the right to keep
bear arms.
Yep. Getting the acronym straight. But if people go to ccrkba.org, and you go on their activism tab, you can navigate to the conference. You can get tickets. Last I checked, there were still some tickets left for not just the conference, but for a happy hour. So you get to meet the different folks in the panels, speakers. Yeah. Garrett and I will be there. You'll be there.
Absolutely. I'm looking forward to it.
I'm going to be speaking that day. It'll be fun.
Woo. Right on. I'm looking forward to it. It's really going to be
I think it's going to be awesome.
good time. Yeah, very cool. Very cool. So, the recent Boston.com article.
Oh, God.
Should teens be allowed
What a
carry?
disingenuous...
That's a very misleading headline.
Should teens be allowed to carry guns in Massachusetts?
They're painting the image of 13, 14, 15-year-olds.
Yeah.
Yes.
When really what we're talking about is people over the age of 18.
Yeah. 18,
Under the age of 21.
When the category also contains 20-year-olds?
Yeah, right. But
So-
they're trying to get everybody into the teen mode.
Opening line of the article, it says, 4 years after a landmark ruling by the Supreme Court of the United States expanded gun rights nationwide, Massachusetts is facing a major legal challenge to its firearms regulations, this time over whether people under 21 can legally carry handguns.
Bruin didn't expand anything.
No, it didn't.
I
It clarified
understand.
things.
It did not expand rights. It recognized them. That's why this opening line stood out to me so much. But the details of the case at hand. So this is there's a case going before the higher level courts in Massachusetts. Young individual Mackay Thompson was 20 at the time state police searched his car. And police say they found a handgun, a fact which Thompson does not seem to dispute. Thompson was convicted of illegal possession of a firearm, but has appealed. His lawyers claiming the state law barring individuals under 21 years of age from obtaining an LTC is unconstitutional, and that otherwise legal adults are part of, put the bunny quotes around, the people, protected by the Second Amendment. So the prosecutors in states are claiming the restrictions of handguns specifically is not an overreaching infringement on the right to keep and bear arms, because that right has been subject to, as they put it, reasonable regulations where public safety demands it.
Wow.
Which is precisely, it's the means and scrutiny that Bruin,
Which is what Bruin eliminated.
denied.
Yeah, right.
Yes.
Bruin's the whole purpose behind Bruin was
The
to shoot that
was to
nonsense
get
down.
rid of the balancing test.
Now, this particular case, I think really what's happening is young individual busted with a gun and is now trying to throw a bunch of different defenses at the wall to
see what sticks.
see what works.
well, it's not.
But it
let's
is a
not
reasonable
deepen it.
question. Some of the questions that the prosecuting attorneys were bringing up, it's like, well, it's not like this individual attempted to apply for an LTC and was denied. So, whether or not this is actually going to work out for Mr. Thompson, I'm not sure. But the question does stand. What do we do with people who are of legal age, who are considered adults by the justice system, for voting, for contracts?
The Constitution.
That's just it for me.
You can be drafted into service, and it's like, but there's this one little thing where all of a sudden you're kind of like this default second-class citizen for a few
You're
years.
not mature enough to carry a gun for your own protection, but you're mature enough to carry a gun for your country's protection. Is it possible that this young individual was possessing a gun for nefarious purposes? Maybe. I don't know. But the basic question to me is, if you're old enough to engage in contracts and you're old enough to join the military and go do the things that they do, and you're old enough to be responsible for yourself, then damn it, you should be able to defend yourself. And that to me means that, but as an adult with agency, you have all of the rights and privileges afforded by the Constitution.
Well, to steel man the other side, real quick. I mean, the argument is, back in, when did we make the drinking age 21? Because the federal government decided to hold everyone hostage for everyone's highway funding hostage.
I don't remember.
But the states have already deemed that there's a certain level of maturity that you don't reach until you turn 21, apparently.
Apparently. Well,
I just to steel man the argument.
I get it.
You
have
don't
to agree with it personally, but
you have to understand the other side, because
Well, the general
what it
philosophy is that, particularly for males, that full frontal lobe development doesn't really happen until about mid-20s.
Right.
Yeah.
But it begs the question of,
they have no problem instituting a draft at 18.
if
Bingo.
someone doesn't have the capacity to understand long-term consequences, impulse control, things of that nature, then
student loan
then
documentation.
then I would question. It's like, well, then how can they understand, contracts, signing leases for apartments,
Mortgages,
getting credit cards? I mean, mortgages. Who knows what?
Oh, you never
people are
know.
going to buy houses,
Hey.
but having children, getting married, all of these things that we're saying that, yes, someone who, if you believe in that philosophy of frontal lobe development, someone who is not mentally developed can do all of these things, yet somehow they're not able to conceivably defend themselves should something happen to them.
Yeah.
It has nothing to, I mean, this is all philosophical, right? It's all academic. The three of us know very well that the purpose behind laws that say 21 is not to do, this has nothing to do with frontal lobe development.
It's a bite out of the apple.
That's exactly right. It has to do with making gun ownership hard. That's it. They don't care about frontal lobe development. They don't care about, personal responsibility and that stuff. So what we're discussing is kind of academic. But to me, you are either an adult with agency and all of the rights and responsibilities, or you're not.
Right. Exactly. Absolutely. So that is the bottom line.
It's created this nebulous alternate class of individuals. Now, part of what they say is like, well, it's not really a full infringement because you can still buy rifles, you can still buy shotguns, which to me doesn't make a whole lot of sense. But
you can't carry them to protect yourself.
The fact that it's smaller becomes a problem. But that is the case. In this particular circumstance, I don't see it necessarily working out for Mr. Thompson very well.
Yeah.
No.
I think it's probably a pretty good example of where these challenges, the problem with these challenges is then it creates a precedent. So when they have, if this gets overturned and more courts say, well, yes, we can actually restrict for this reason, that reason, that's another court case that you have to overcome when you start challenging these laws. Well, and I think it's a good argument of why it's so important to find really the right people to file these challenges.
Yes.
I mean, I cannot fault this individual for doing absolutely everything in their power to avoid punishment. But
sure.
Here we are.
Well, we're going up against folks who have run into the legal system. Most of the time, exactly. I mean,
I see where you're going with it.
Most of the time, you're not getting
the perfect plaintiff every time.
There's no such thing as a perfect defendant in these cases, or even a perfect plaintiff.
It's less about the individual. The individual is more like a vehicle for getting the concept addressed.
You have to go to war with the army you have, which I said to you earlier. But it's one of those things where, yeah, sure, bad facts make bad law, but at the same time, we're in the First Circuit Court of Appeals. We're not getting a favorable court. We are the fodder. We're cannon fodder for a circuit split.
Yeah,
that's really where
we are like one guaranteed side of the circuit split. Yeah.
Which is from the beginning, Jim and I and the argument he's been making that we've been talking about since the very beginning of the debate over 135. In FCAB, they keep saying, "Oh, well, the courts need to decide this." Like, well, that's the moral issue, isn't it?
Yeah,
you're going to see a whole bunch of folks who get their lives ruined over this stuff.
Yeah, right.
Before
it doesn't go to court until somebody's screwed over by it. Yeah,
and before we get resolution one way or the other.
Yeah,
we just have to do our best to convince people to vote the right way. We have almost 600,000 gun owners in Massachusetts. If we decided to all vote as a block.
Oh yeah, we'd overwhelm them. So the issue, one of the side issue that I have is like what you alluded to in the beginning is that the framing and the headline of the article itself
it's ridiculous.
Is such a bad faith representation of the issue from the Globe.
It is playing to an emotional
Boston.com.
Yeah.
It is obvious where they come down on the issue, and it is obvious the conclusions that they're trying to get everybody to draw.
They're very interested in showing you a very specific angle and perspective on it. But we're going to have to see. We'll see how this one goes.
We'll see.
I wish the defendant the best of luck. And we'll see what happens.
We'll see.
I mean, thankfully, public opinion does not have any bearing on the outcome of circuit court decisions.
Ideally. All right, let's move to the Supreme Court. Vincent v. Bondi. On March 2nd, the Supreme Court denied certiorari in the case of Vincent v. Bondi. The question presented in the case was whether the Second Amendment allows the federal government to permanently disarm petitioner Melinda Vincent, who has one 17-year-old nonviolent felony conviction for trying to pass a bad check.
Now, that stems from a circuit split. So that's, in the defendant's case, she has been denied the right to keep and bear arms based on this felony conviction.
And probably the right to vote, too.
However, in the Third Circuit en banc ruling in NYSRPA v. Bruin, the panel of justices held that particular statute, 18 U.S. Code 922 G1, criminalizing the possession of a firearm by anyone with a felony conviction could not constitutionally apply to a plaintiff convicted of making a false statement to obtain food stamps. It was one of the things that they came up with. Yeah. They also cited other examples of conflicts from other circuits. So we have a couple of fundamental questions to tackle. Is the primary purpose of the criminal justice system retribution? Is it rehabilitation? If the court says this is the debt you must pay to society and you have paid it, can we or should we continue to place this scarlet letter on certain individuals? And part of the calculus for the Supreme Court denying this petition almost certainly tied to the federal firearms rights restoration that finally came back under the DOJ umbrella.
Right.
Yeah. Yep.
And has finally received some funding so it can actually operate, even if it only operates at the speed of government. How long that lasts or to what level it functions is anybody's guess.
That's the problem with executive action.
But it again, in that same vein of who is and isn't allowed to defend their own lives, these are the questions that we're going to have to start asking is, someone with a quote unquote felony conviction, something nonviolent, a long time ago, they've paid their debt to society. They're doing all the things.
Right.
Is there a path to full rights restoration?
My position is like fully libertarian on this one. I am fully of the opinion, and I realize that it's not popular among certain aspects of society, but if you have done the crime and paid your so-called debt to society, the way you put it, then all rights and privileges should be restored to you, including the right to keep and bear arms. Now, somebody who has written a bad check has not shown themselves to be a danger to themselves or others. So this is not oh my God, we have to disarm them or they're going to shoot the place up.
Well, I think in this particular case, it was an intentionally. It wasn't like someone just accidentally overdrawn. But
that does not that to me. That's
painting the picture.
That's a fair analysis, and yes, you're absolutely correct to bring that up because it wasn't an accident. All right, she did it on purpose.
Right.
Still, to me, that does not rise to the level of loss of constitutional rights.
I don't disagree with that. I mean, really.
Neither do I. Obviously.
Are we talking about if someone breaks the rules? Are we trying to punish them? Are we trying to rehabilitate them? Are we trying to do both? And how do you measure that benchmark? And then once that person does complete those things, then I believe they should be able to return to the game as a full participating member.
When is your punishment over? I mean, at this point, why not just throw somebody on the back of a horse blindfolded and slap its ass?
Well, yeah. Old scapegoating, right? Slap them on the ass and send them into the desert.
Well, and if there is no pathway to redemption, what is the motivation to redeem oneself?
Yeah. And again,
there isn't one.
I'm sure that we're discussing this again. It's all academic. The purpose of all of this.
I would argue it's not really academic, honestly.
The pragmatic purpose of denying felons the right to keep and bear arms is to make gun ownership hard. It all boils down to that, right?
Yeah,
that's why people defend that.
It's not in government officials' interest for the populace to be armed.
Right. But on an abstract kind of academic level.
Yes. And I analyze every action they take from that point of view.
Yeah.
Okay, I'm in power. I'd like to stay in power. How do I keep folks from getting me out of power?
And this is one way to do it.
This is the way to do it. Because once you take away a person's ability to defend themselves from anything, or from you or anything, then you have the ability to force them into anything. Yeah. I mean, government, by definition, is the monopoly on force.
Right.
If that gets diluted by those pesky Americans being able to appendix carry a SIG P365, then you're not doing your job as a heavy-handed government official.
Well, I mean, I think it's certainly arguable that if this is my personal belief, if someone is deemed by courts and through due process to be so utterly irresponsible and dangerous that the mere fact of them holding a firearm in their hand presents such a public threat that you would have to incarcerate them again, then they shouldn't really be out in public in the first place.
Exactly.
Would be my personal opinion.
So Jim always says something very similar about red flag laws.
Yeah,
right. That's like a perfect parallel.
If you're that dangerous, then you ought not be out on the street.
You've identified the next mass shooter. all you're going to do is take their guns away?
Yeah, and send them back.
Can they still get a CDL and drive propane around? Well, like, what are you doing?
Well, unfortunately, the U.S. Supreme Court denied certiorari in this case.
Of course they did,
kind of,
they're wimps.
I guess punts the can down the road as far as, how do we treat those that have been incarcerated as they are re-entering society. I think it's something that is going to have to be tackled sometime, at least in my lifetime.
So we don't know,
to
we're
really
not privy.
Evaluate our criminal justice system and how we're operating.
Kavanaugh, the sad boy.
So we are not privy to the reasons that the Supreme Court deny some cases and grant other ones. So that it's a natural tendency to assign a strategy to it. Well, they're not taking this one because they're waiting for the perfect case to come down the pike. We don't know that.
I think they should be forced. I think they should be forced to write an opinion of why they denied cert.
I could get behind that.
I don't understand why they're not. They don't have to do their job.
Tens of thousands of opinions, at least even if they had a clerk take notes. But
eat one. Do your job, dude.
Something would be nice. Anyway, we do have a little bit of Supreme Court news to talk about. Hamani finally went to
so the Supreme Court did accept the U.S. v. Hamani Second Amendment case. So we were talking about March 2nd was the denial for the previous case. On Monday, March 2nd, the Supreme Court heard oral arguments in the case of U.S. v. Hamani. It's an as-applied challenge to 18 U.S. Code 922 G3. The federal statute prohibiting the possession of firearms by a person who is, and we'll put the quotes around this, an unlawful user of or addicted to any controlled substance, close quote.
Hunter Biden.
And whether that violates the Second Amendment rights of in this case, the respondent, Ali Daniel Hamani. Now, there was, I listened to the oral arguments. I think there were definitely some strong arguments in favor of the case, particularly the void for vagueness argument. What does habitual mean? What does addicted actually mean?
There were some pointed questions along those lines.
Yeah, they referenced, old school temperance movements that said, the idea was about the habitual drunkard. Yeah. And they're like, well, if you have 8 shots of whiskey a day, you're an occasional drunkard. You have to drink double that to be a habitual drunkard. Now, but this also comes into like the 4473 we fill out. And I thought there was one point where they kind of hinted at it of the Fifth Amendment issues where it says like, are you an unlawful user of or addicted to? And they specifically cite, marijuana and,
the use or possession of marijuana remains unlawful under federal law. We're talking about.
That's Schedule 1.
Yeah. So are you an unlawful user of, addicted to marijuana, any depressant, stimulant, narcotic, drug, or any other controlled substance? Warning, says the form. The use or possession of marijuana remains unlawful under federal law, regardless
Schedule
of whether,
1.
Regardless of whether it's been legalized or decriminalized for medicinal or recreational purposes in the state where you reside.
Which is kind of funny because some folks who use like SSRIs lawfully probably should be less
not that anybody should be denied their rights, but if you're going to take a harder look at somebody, there are drugs that are a lot more
that are prescribed legally, a lot more than like your local pothead who doesn't want to get killed walking down the street.
Well, the big Fifth Amendment question was, are you being compelled to self-report a criminal status without due process?
Absolutely.
Well, sure.
But I think really what it came down to, in most of this case came down to, was really dancing around the question of, to me, the absurdity of marijuana being listed as a controlled substance, particularly at Schedule 1,
just in general,
compared to things like alcohol. Yeah.
Well, that was the big gateway drug scare of like the previous decades. I remember that when I was a kid. If you took a hit off a pot tomorrow, you're going to be doing crack and heroin.
But I also think that's a little bit outside of the purview of the court.
It should be.
I mean, well, that wasn't what the case was about. That was not the issue at hand. But
it's legislating morality.
But realistically, so many of the questions seem to kind of just revolve around that whole issue of, it is in the process, and there are talks among in the current administration about listing it back as a Schedule 3. Yeah, and one of the questions was like, well, what are we really arguing about here if you're going to roll it back anyway? And then we're talking about different stuff, but. One of the things that the government really struggled to answer was even as a Schedule 3, it's still now it's still a controlled substance.
Controlled substance.
So how do you then answer that question?
Well, so is Adderall.
And what they were basically saying is like, well, yes, it's technically a controlled substance, but we really don't care about the other schedules. We really only care about Schedule 1 and Schedule 2. And I feel like the justices kind of failed to narrow in on that. You're basically saying like, yeah, it's the law, but we're just selectively enforcing what we think is important.
Right. So if
Which
you're
I
going
think was a bigger issue.
Right. If you're going to,
that's just laziness.
If you're going to enforce like restrictions on controlled substances, then why aren't you doing them all? Now, I don't think they should do them all, but the fact that you're right, you're right.
Selective.
The fact that they're doing it selectively.
Now, interestingly, I found it really funny some of the questions that the justices asked, and I'm curious of what window that may or may not paint into their personal lives.
Which one specifically?
When someone were like, well, what if someone takes a gummy like every couple of nights?
Was it Tanji Brown Jackson?
No, it was Gorsuch of all people. He's like, well, if somebody takes like a nighttime CBD gummy a couple of times a week to go to bed, like, is that really a problem? It's
like I have a friend who did.
I don't know, Justice Gorsuch.
It was really fun. And then,
what's your address again? Says the DEA agent in the back of the room.
But then I think it was like either Sotomayor or something. She's like, well, let's just bring up a hypothetical of like ayahuasca. And it's like, that didn't just drop out of a hat.
Right
either.
on. You just thought that up just now, right?
And hey, listen,
she listens to a lot of Joe Rogan, okay? She's a red pillar.
I think if anybody needs to, have a little bit of touch with the empathetic side of themselves, maybe a Supreme Court justice. I'm not going to give them a hard time.
Somebody made an allusion to Thomas Jefferson takes so many drinks like every night during his is he a habitual user? And
he said he didn't really care for alcohol. He just had like 3 or 4 glasses of wine a night. There was another guy. He's like, he drank a tankard of cider every morning, which is basically like a pint of beer.
Okay,
I think most of the case just revolved around like, why are we arguing about marijuana here?
I got the impression,
relative to everything else, like of all the things. And I mean, they kind of really didn't dive into it, but I mean, the reality of
bourbon.
Well, the reality of alcohol, and I looked at some of the numbers, it's like 40% of all violent crime involves alcohol in some form.
It sure does.
Yep. 45% of assaults, 63% of domestic violence, 37% of sexual assaults. Like when you look at
1% of Goal Podcast.
You're gonna have that cork squeak in the background.
Yeah, right?
But
I tried to make it quiet.
But it's one of those things where, like, to me, it's like, but it is a cultural thing that we have and that we've done for a long time, and we recognize that yes, some people have an inability to control themselves under certain substances, under certain conditions.
Yeah, but that doesn't mean.
But we all relatively agree. It's like, well, the rest of us can hang, so kick the guy who's fighting out of the bar and let's have a good time. So I think that's really kind of what they were getting at with even with marijuana, even with some of the other things of like
marijuana is not alcohol to begin with, which is such a funny thing.
Well, let's grant the argument
outside of the purview, but
the only reason it's anything at all, like I said, is because of the panic, the big scares in the the 50s and 60s.
I would argue it was the textile industry that tried to keep hemp down, but that's fine.
But let's say, all right, it is a substance
that's the Cato Institute argument.
In some form or fashion alters the state of mind.
Yeah, sure.
There are some people who are going to be able to do it responsibly. There are some people who are going to do it irresponsibly.
Absolutely, just like with alcohol.
Right. So I think that's kind of where they're revolving around. I'm going to be very interested to see how they write this decision, how they approach it, the tailoring of it. I think what they're going to find, if I had to read the tea leaves just based on listening to the oral arguments, I think as an as-applied challenge, they will rule in favor of Hamani.
I think so too.
Not as a facial. I don't think it's going to be a very broad scope.
Because how can it be? It's going to, it would call into question the entire schedule.
Right. They're not going to slap it. Right. They're not going to slap it down.
I honestly cannot believe that this is the case out of the last two we talked about that they took up.
Yeah.
But
this is like far-reaching implications.
However, they really did ask some pointed questions, and the subject of void for vagueness did come up.
Yeah.
Of like, okay, well, they might actually push and say, you're going to have to now define what does it mean to be habitual? What does it mean to be addicted to? What does it mean to be abusive of a substance?
Well, it's because all 9 of them grew up in an era forward where marijuana, alcohol, coke, and other drugs were like regularly used at the colleges they were required to go to get there before they got their law degrees. I mean, come on.
Saying there's some exposure.
Well, I'm just saying that by default, every single one of them had to go to an institute of higher learning in order to get to the point where they are.
And ironically, to me,
very different world.
It speaks to the previous case that they didn't take up. Is my personal belief is the opinion that the difference between someone with no DUIs and one DUI is luck. So there's a lot of these things where people want to judge from on high because they haven't had that experience in that circumstance. Where here's you have a lady with a 17-year-old felony conviction. Should she be punished forever for that particular mistake?
Right.
I think some of the justices are looking at this going, listen, I know I think everybody knows plenty of people that consume some sort of cannabis product with some level of regularity, whether
absolutely.
It's CBD for joints, whether it's cannabinoid, all over the place.
I hear the older you get, the harder it is to sleep a full night.
So
I can attest to that.
And listen, I can attest to people that I knew that were very sick, that used cannabis products, that were able to then sleep and eat and live a more I think fulfilling life.
I think having cancer and not being able to get some form of marijuana is a crime.
Well, there are some where I just go, I think the rule should just not apply to you anymore.
I've never.
Well, I think the rule shouldn't exist, but I mean, I agree with all of your justification.
The hardest drug I've ever done in my life is like 100+ proof whiskey and like a cigar every once in a while. I've never touched anything, but like I would never deny anybody
took
the ability
3 Advil instead of 2.
Yeah, that's right.
Really
off
rebelling.
label.
I've never smoked pot. I've never done any of that stuff. But like, I think it's ridiculous that we're judging folks on their ability to function in society, on whether or not they can control themselves.
That was a lot of the question of like if person A goes home and likes to have a couple of glasses of wine, and person B likes to go home and have a 5 milligram gummy bear. Really, what's the difference if they're as long as they're productive members of society, they're playing by the rules, they're they're fulfilling all their responsibilities.
As long as you're not putting other people in danger. Right. That's the limit. That's
if you're the crux of it.
Yeah, I don't care if you get blasted at home. I don't care if you flush your life down the drain because of drugs. Yeah. That is not my business.
Exactly.
My business is when you put other people in danger. And
my right to swing my fist ends at your face.
And my thought is, as long as you're not asking me for money, as long as I don't have to pay for your Doritos,
as long as you're not hurting anybody or draining their resources without their consent, it's nobody's business.
I don't care.
Although I will say, and we'll wrap on this. Our favorite Justice Jackson.
Oh God, she is such a piece of.
She's
probably great on this issue though.
Well, interestingly enough, I mean, she was doing it sarcastically, but I think she accidentally made some salient points. But she was kind of griping. It's the Bruin test.
Blind squirrels, broken clocks, and Ketanji Brown Jackson.
She was kind of, it was a clear disdain for the Bruin decision, but she was basically saying, it's like, well, I don't know what we're supposed to do because, the Bruin test says the only thing modern legislature gets to do is follow the judgments of founding era legislature.
It's like, yes.
It's like,
now you're getting it. Yeah. You're getting it. But unironically, yes.
Hence the point of a cohesive, continuous society.
But saying that, they don't, under Bruin, they're not crediting the judgments of modern legislature about who is dangerous and who needs to be disarmed. And that you have to have
interpreting the opinions of the previous version.
But she was complaining about the policy judgments, that you have to have a policy judgment at the founding that matches the policy judgments today under the Bruin. Now, she was kind of... to me, was rather sarcastically going, it's like, well, they didn't specifically say, this drug schedule at the founding, so how can we have any regulated drug scheduling? Kind of rolling her eyes in that fashion. But
everything that she says is couched in her. Now, we've all come across activist judges before, and there has, in my experience or my opinion, never been a more activism-driven justice on the Supreme Court
but she's also like a potato. She's not just an activist judge. She's doesn't have any intellectual curiosity.
Every single argument she makes, every single decision that she signs on to has to do with her personal politics.
Yeah.
There's nothing to do.
Well, there's two things.
The First Amendment stops us from doing whatever we want.
Yeah.
Why would we want that?
Like, that's a bad thing.
So there's two things that I think Justice Jackson does that's unique to her that the other justices don't do. Number one, she very clearly falls into the benevolent dictator fallacy of the rules applied to everyone, but they shouldn't apply to me because I have the best interest of everyone at heart, and therefore I should be able to just dictate whatever I want. I know best. Yeah. The other thing she does that I think is unique to her that I don't see the other justices do to the extent that she does it is a lot of the justices just ask, leading questions for sure. Mm-hmm. They'll pose a hypothetical and maybe describe it.
They're looking for you to say something.
Yeah. What she does, and this is how it sounds to me, is it sounds like she's having the debate that the justices are supposed to have behind closed doors with the attorney in the room. And she's arguing her point with the attorney on what she wants the outcome to be.
Which you shouldn't do.
Which realistically you don't want a justice to do. So she's not very talented at hiding her opinion.
No.
The way some of the other justices are. Most people can kind of figure out like where
couch it in their question,
where Clarence Thomas might fall, or where
Alito,
Elena Kagan might fall down. Yeah. But
if your name isn't Antonin Scalia, I don't really trust you as a Supreme Court justice if you ask too many questions at oral argument.
Well, that's the third thing that's different about her is that she's never bothered to actually acquaint herself with the Constitution. So
I love that you just brought up the benevolent dictator thing. Do you think your morality is superior to
exactly?
The next guy?
So it's like if you were given supreme whatever leadership control,
if you were God,
no legislature, no courts, no anything, you are the supreme leader of the United States, would you take it? And I think a lot of people would say yes, because my way of thinking is the best.
Sure.
But that is the whole idea of the benevolent dictators. Like, well, if I was given ultimate control, then
if everybody would just listen to me, I would set this whole thing straight.
said every libertarian ever.
All right, moving on. Rhode Island from Jeff's neck of the woods. Rhode Island H8073. So they decided that that horrible assault weapons ban that they passed a couple years ago didn't go quite far enough.
Yeah, they took grandfathering and put it on hospice care. So July 1st of 2026, Rhode Island's recently passed Chapter 11-47.2-2. That is the restrictions on manufacture, sale, and purchase of prohibited firearms is scheduled to go into effect. That's coming July 1st. This is Rhode Island's version of an assault-style firearms ban.
Yeah, we covered this a few
basically,
few ago.
Like the way to think about it is Rhode Island is Massachusetts Fredo.
I can handle things. I'm smart. Not like everybody says. Like dumb. I'm smart, and I want respect.
I'm smart. Not like everyone says.
So Rhode Island legislators may have admitted a mistake in their passing of the ban because they've already filed House Bill 8073 to fix their glaring oversight. The original bill only banned manufacture, sale, and purchase. This new bill would amend it to include banning the mere possession of prohibited firearms. So the new law reads, or the updated law would read, should this bill passes, no person shall manufacture, sell, offer to sell, transfer, possess, or purchase a prohibited firearm except as otherwise authorized in this section. And what it offers you is a person who lawfully possesses a prohibited firearm prior to July 1st, 2026, may sell or transfer their prohibited firearm to an FFL or to an individual outside the state by December 31st, 2026.
Immediately. Basically, within 6 months of passage.
After that, possession is against the law.
So that's a taking.
This is confiscatory.
Yeah.
Yes.
That's a taking.
So your options are destroy it, turn it in for destruction, or get it out of the state by the end of the year. And that's only if you owned it prior to this so there's a grandfather date of July 1st. And if you have a firearm before that, it's essentially saying you are given a 6-month grace period to get rid of it.
Eat shit, Rhode Island.
So 180 days to export your firearm from the state or submit it for destruction. As we sit, the bill was introduced on February 27th with 9 sponsors, referred to the House Judiciary Committee. Typically, the General Assembly adjourns sometime in late June. So we have about 3.5 months to see how this goes.
I feel like Rhode Island they passed that BS like 2 years ago, and then they looked around and said, nobody said anything. No, so let's go do it. You know, let's
they're like Massachusetts.
Let's do the rest of it. It's ridiculous.
Like Massachusetts' younger brother. They're like, we're gonna do it even harder. Fudge you.
But it's like,
dude,
no grandfathering and then taking.
So is there a chance that this is gonna pass?
Yeah,
there is chance that this could pass. Rhode Island has some really interesting issues.
So
where in all of these committees and in these joint committees, people who are not in the committees can vote on committee issues.
Get out of there.
So, yeah.
Why do you live in that state?
It used to not suck.
No, it didn't. It always sucked.
That's true. That's true.
Rent's cheap.
The rent was cheaper, and
because
it's funny.
Nobody wanted to live there.
Well, for all the taxes that you paid, has the worst roads in the country every year for like the last decade. So, in my opinion, this is a direct result of the Supreme Court denying cert for Ocean State Tactical v. Rhode Island. So I think that what gun control advocates look at is they look at that denial of cert and they say, not only did we dodge this bullet and metaphorical bullet, but that means that what we're doing is A-OK, it's constitutional, and that we can branch this out to other things.
Yeah.
So I think they looked at the denial of cert in Ocean State Tactical and said, we can actually ban possession.
Yeah.
We can ban possession with no grandfather date.
Yeah. Let's
so
run
now
with
this
it.
is now this is the thing that they want to jump into.
Let's run with it. Well,
but that's what Rhode Island is doing. So
also in Rhode Island, though,
going on
is La Cosa Nostra.
It was almost better when it was run by the mob.
I wish it still was.
So also in Rhode Island, so we have House Bill H 7557 and a parallel Senate Bill S 2611, and this is the Rhode Island Firearm Industry Accountability Act of 2026. Now, these would establish 3 components, and it says no firearm industry member shall, advertise, market, promote firearms industry products in any manner that promotes unlawful sale, use, or promotes risk to public safety.
which is not a thing.
What the hell does that mean?
About as nebulous as it could be.
Yeah.
It also says, no industry member shall provide an industry product.
I would argue that's more specific than they meant it to be.
Another industry member when there's reasonable cause to believe, blah, blah, blah. But it also says, and this is the thing that I think is probably the stickiest part, is it says firearms industry members shall establish, implement, and enforce reasonable controls to ensure compliance with the provisions of this chapter. To me, in my read of this, that would include glasses, contact lenses. So anything that allows you to see would be a firearms accessory. Anything that allows you to hold a it's the list is endless. Now, of course, as we've talked about before, this is they're trying to encapsulate a whole bunch of things, and it's roping in a whole bunch of other stuff.
It has nothing to do with glasses. It has nothing to do with optics. It has to do with setting up a permission framework in the law that says that once something goes wrong, they can refer back to this law and say, well, we told you.
So if you file a civil lawsuit under this framework, what it's saying is that the firearms industry is by default guilty unless they can prove otherwise.
That seems to be what it's saying.
No, that is literally what it's saying. That is actually what it says.
That bill has been referred currently to House Judiciary Committee, and that's where currently it's set. So
we have a little bit of action in Rhode Island below the border, south of the border. Coming back to Massachusetts. So if you're a firearms instructor in Massachusetts, you likely received an email this past week about the new basic firearms curriculum requirements. Despite being declared an emergency by the governor, Massachusetts State Police had 18 months,
which they legislated after the fact.
Yeah,
to come up with answers for all the new training requirements outlined in the Chapter 135 Intolerable Acts to go into effect April 2nd, 2026.
I don't know that we need to read this whole thing. Number one, if you're an instructor, you received the email. Number two, if you're not an instructor and you didn't receive
it's available on the web.
It's available on all the websites. Go to goal.org. Download it. You can find the text there. It boils down to this Massachusetts State Police had 18 months to prepare for their training mandates.
18
and
months
they didn't
plus, by the way.
freaking do it. Yeah, no, ever since the law passed, they knew what it was going to be. Or ever since the law was in text, they knew what it was going to be. And then it was signed, and then they've spent all this time going, we're going to promulgate new stuff. This is what it's going to be. And then less than 30 days from the deadline, they send an email to every instructor in the state saying, well, you guys figure it out and let us know what you plan to do, and we'll decide whether or not to approve it.
Yep. They said all BFS instructors are invited to submit their curriculums for review and approval. Instructors should also submit a written examination consisting of 25 multiple choice questions addressing each topic of instruction. Now, at this time, the regulations around live fire training have not been finalized, and it openly said that instructors should still submit their curricula for approval.
They're still not late.
With the understanding that each course will have to be resubmitted and reevaluated again with the live fire regulations once they are promulgated by someone somewhere.
Once the state figures out what they want.
Yeah, but
so meanwhile,
but the state is the colonel of the state police, the state is also supposed to come up with the test. So
yeah. It is so on brand for the way that this entire Chapter 135 rollout has been to me. Waiting until the 11th hour and then saying, oh, I don't know, you guys, figure it out. And so you guys have got to be fielding questions left and right at goal. The phone lines have got to be burning up.
So John, the biggest question we're getting, actually it's two questions. It's how do I write an exam?
Well, yeah.
And also they weren't expected to have to do that. The colonel of the state police is supposed to promulgate those.
Yeah, by the law, by Chapter 135.
By statute.
Yep.
And the other question we're getting is, if I don't submit a curriculum, do I lose my teaching certification?
Yeah, your BFS number.
So...
because otherwise you're going to have a certificate saying that you are certified to teach a different curriculum.
So that's where we run into it. So
what does that even mean for the average instructor?
So you guys are both instructors.
Oh yeah. Yep.
So have you submitted a curriculum yet, or have you looked at it?
Not yet.
So there's a checkbox that says, I certify that this can be used by other instructors.
Okay.
Or you can check no, that it can't. So I have a feeling that they're going to go and say oh, well, we're not going to decertify anybody. You're still an instructor. You just have to figure out.
There's just no curriculum that you can teach.
Yeah, you just might not have a curriculum that you can teach at the moment, and you have to ask permission to teach this one.
Yeah.
Which is made all the more insidious by the fact that most instructors teach the home firearm safety or basic pistol safety course.
Right.
And this is going to have to be a modified version of that. So Goal, John Green has submitted basic pistol with the 6-slide addendum, which is written horribly, by the way.
Yeah. No, it's pure propaganda.
Well, it's not even propaganda. It's also it's also wrong. I went back through all of my old law school.
Well, I call it propaganda because a lot of what it says is you can ban your way to utopia.
Well, it's not even just that. It's
right.
Well, no, the force continuum stuff is wrong.
Oh yes, that is also categorically wrong, and we all saw it with our own eyes with the Scott Hayes case. And
all right, so for the listening audience, what they're referring to is the addendum to the basic stuff. Is that the state also sent in that email a series of sample slides covering things like suicide prevention, injury reduction, use of force.
Use of force
is disengagement, conflict avoidance, things of that nature. Some of it is objectively wrong.
Most of it is all just it's stuff that you don't have to pay attention to, conflict avoidance. It's talk to the guy, walk away, create distance. Is that kind of stuff? But
it's stuff that they threw into Chapter 135. The Giffords or whoever the hell wrote the actual law threw into Chapter 135 and now statute.
Well, it's very clear to me that the slide deck on the whole de-escalation stuff was written probably, if the email came out on Wednesday at 7 p.m., it was written on Wednesday at 6:30 p.m.
Yes, absolutely. But the part that bothers me the most is the chasm between the first slide regarding the force continuum and the castle doctrine stuff. It like the first slide just deletes the castle doctrine from existence, and then they're like, oh yeah, that exists. I don't want to go back and fix the first slide. It's horrible.
Yeah. So they add this stuff in.
It's untrue.
Yeah. So they throw this stuff on top of courses that they have not promulgated, that they have not vetted. They're saying, here, take all this stuff, throw it into a pile, submit it. Maybe we'll approve it. Maybe we don't. And by the way, as of this recording, we're 20 days away from the deadline.
And I got to be honest with you, if the Mass Chiefs of Police hadn't endorsed the Senate version and like gone along with this, I would give them a pass. But at the moment, like, screw them. They went with it.
All kidding aside,
figure it out, fellas.
We have been, I think, very tolerant and have spoken well about a lot of the people in a lot of the positions. But to me, I cannot look at this and how this was handled as anything short of contempt for the people expected to comply. It's like you had 18 months to come up with something. And 30 days out, you said, everybody else figure it out.
We're not going to bother. You guys do it.
And I'm not, please do not take this as as letting any of those folks off the hook. But on the front end of this thing, is the fact that all of this was unfunded. This is underprioritized,
that's pretty typical,
unfunded, unstaffed, uncared about. So in order to get a lot of this stuff passed, they have to avoid assigning funding to line items because the governor can just go in and say, hey, we're not funding this, we're not funding this, we're not doing this. So the legislature can either be like cut off at the knees or say, hey, governor, you have to do this, or just do nothing at all. And just saying, hey, you need to figure out how to appropriate funds to do this thing.
I get that this is all sausage making, like the whole funding thing and line item vetoes and all that stuff. That's all. I don't care. That does not make it not enforceable law. That means
I agree.
I don't care about the people in the state house who say, well, this is not funded, so we can't. God damn it. I'm still expected as an instructor and as a citizen to follow this crap.
I mean, look at a guy like, full disclosure, look at a guy like Bill Dalpy, who's on our board. He runs a school.
Yeah.
That is his bread and butter. That is how he makes money to fund that's how he pays his mortgage. Like, that's not fair to a guy like that.
The way that you put it, Jeff, is exactly right. It shows the contempt.
The fact that I can be locked in prison for this and you couldn't even be bothered to spend an hour on it, to me is like, that is an insult on a level that is just beyond the pale.
Unconscionable. I hate that we have to leave it like this, like unresolved. Yeah. But unresolved is where it is. We are, like I said, 20 days out from the deadline. People are still going with their hands in the air going, I don't know what the hell are we supposed to do.
We have lived in this gray morass of nonsense since 2016.
And there are departments now denying taking LTC permits because they're like, we think the thing's going to change in a couple of weeks. So now people are being
sit tight. We're working on that one.
I understand it's in progress.
Freaking out, and there's a lot going on. The pieces, like the legislature, every opportunity they get, they throw a bomb in the middle of everything
because they hate us.
So
they hate us.
The takeaway
really ramped up,
huh? Well, it's understandable that it like gets you back here up. So understand, people listening. This is like, we hate this. It is unresolved as of this recording, but we're not doing anything.
No.
John has been working his magic. He's been submitting courses. Jim, you guys at the office have been burning it up.
We have other things in...
Things are in process. Okay, don't take this...
Depending on what happens, we have different contingencies.
Don't take this diatribe as some indication that things are not happening.
We're not taking a laying down. I mean, it's certainly a hell of a gripe session.
So... things are happening.
Yes.
I'm hoping that we can have some some concrete resolution in upcoming episodes. We'll talk about actual things that are happening. We can't talk about things that are, halfway considered right now. This all came down as of this recording less than a week ago. So we are all still responding to it.
My blood pressure is double digits points higher than it was last week.
You know what the real kicker is? By the time this podcast airs, we could get 2 more guidance letters that say something entirely different.
Yeah,
but don't listen to them because that's
entirely possible.
Entrapment by estoppel.
So watch this space. This is not over.
Hell no, it isn't.
We will have more to say in coming days. Let's flip to something a little happier. We have an annual meeting coming up.
Yeah.
We've been dropping a stinger at the end of every episode.
We can all yell about it in the same room.
So go to gold.org, get your tickets for the annual meeting coming up.
Yeah, maybe I'll come off the ceiling by then.
I might not be.
I'm telling you, my neighbors probably heard a whole lot of language that they're not used to hearing from my apartment.
Really,
other night.
Really pissed off. So what else is going on at the office?
A whole bunch of stuff. I mean, he's
trying to pocket one of your bottles of bourbon.
It fits right. It fits perfectly in a hoodie pocket.
Naturally, the more expensive of the bottles too.
Oh, it's my favorite. I'm a big Russell's guy. But one big thing, town meeting season is coming up.
Yes.
I recorded a video today about that. That'll be out tomorrow. We have sample language for you to exempt your town buildings from the sensitive places restrictions.
That's right. Buddy of mine in Charlton was involved in that effort.
Excellent.
There, so yep,
they did a great job. But we have sample language. It's going to be on the Goal website tomorrow. I recorded a video today. I'm finishing up editing on that in the morning.
Cool.
We'll have that out. But it's kind of a little bit of a recap of what we talked about last year, because this was an issue back then. This was an issue last year too. But we have sample language that's going to be on the website tomorrow afternoon.
Nice.
That'll be live.
That'll be out by the time this.
Oh yeah, that'll be out. Yeah.
Yeah. By the time this airs, it'll be on the website.
It'll be out Wednesday, March 11th.
Yep.
So yeah, I mean that's a big one. New England is unique as far as
to say the least.
Well, as far as municipal governance goes. Yeah. The board of selectmen, town administrator, manager, open town meeting thing is not the norm for the rest of the country.
It's pretty unusual outside of
we call it circus season. So just pay attention to what your board of selectmen is doing right now, because they're going to be finalizing your town meeting warrant. The articles will be out. Look for that red book in the mail. And if you want to try and exempt your local administrative buildings from Chapter 135.
As you should.
Yeah, take a look at the Goal website. And if you have any questions, shoot me an email, mikeh@goal.org. I will get back to you, and we will I'll walk you through the process.
Perfect.
Yep.
Perfect. What else is shaking?
This has been the most tumultuous 2 years. I started at Goal 5 years ago thinking that this would be like a fun gig. And it is, but my God.
For entirely different reasons.
They just swung a baseball bat at our faces 2 years ago, and we've just been reeling.
So what you're saying is you're kind of unlucky.
No, I'm lucky because this is like the fight of a lifetime, and I'm excited to be a part of it.
Right on. Right on. We're excited to have you a part of it. Yeah.
Massachusetts is worth saving.
It's hard to face stuff like this and not turn into like Eeyore and go, "Oh, it sucks here.
I am jaded as hell."
Terrible. Well, yeah, but you know what? You have to be able to, if you're not going to like succumb to despair, you have to maintain some kind of positivity. And
if it weren't for the weather, I'd be skipping everywhere. I hate snow more than our gun laws.
I don't know about that.
I don't either, but it seemed like a funny thing to say.
Well, as a means of a public service announcement, we are in officially fall spring for Massachusetts.
75 degrees today.
I know.
I love it. Oh, I'm so happy.
What I will say is Garrett's snowblower is broken.
Mine is too.
So if people want to donate to get Garrett's snowblower fixed, I think that would guarantee that we get no more snow.
That's fair, because if your
snowblower works, you're not going to need it.
Exactly, especially if it costs money to get it fixed.
Mine doesn't work either.
Good. Right. We're fighting the good fight.
Yeah, we're in fall spring. We're gonna have one more kick in the pants of Mother Nature reminding you how much she hates your guts. and then we'll go back to some better weather.
Some not horrible
And
weather.
then we have got hunting season right around the corner.
Yeah.
To it.
I'm gonna shoot that turkey in the face so hard.
Can I make a confession here?
What's that?
I have never been hunting in my entire life.
We can fix that.
I'm not a hunter.
Can make it happen.
We can fix that.
I don't like venison.
You don't have to like venison.
No, I like poultry.
like
I'd be
turkey?
totally into turkey hunting.
We can fix you some turkey.
I'm into it. I just I don't like venison. I've never felt right about shooting a deer. I'm not going to eat.
So here's the thing I will tell you.
I'll donate it.
If there's a couple venison recipes that I would like to make that I think would turn you around. However,
it's a mental thing.
Wild turkey is phenomenal. It is fun as hell to hunt.
I'm on board for birds.
If you want to get your stuff together and get your hunting license and permits and all that stuff together, I will put you on a bird this spring.
That works. I'm into it. The venison thing. It's not the taste. It's not the flavor. It's not any of that stuff. It's like a weird mental block. I don't know why.
Mike saw Bambi as a kid and he just never recovered.
No, because I don't know what it is. I don't know what it is. It's I don't know. God, I'm gonna get so much hate for this episode.
All right, let's wrap this.
I'm very much pro hunting, by the way. Like pro hunting, anything you can legally go for, on board. I just eating it's just not my alley.
We'll have Garrett trim it up, but seriously, if you are,
I'm into trying it again.
If you are interested in getting out there to at least have that little bit of touch point and experience for dealing with other people who are hunters,
I'm into it.
I will get you on a spring bird this year.
Mike Harris, Public Policy Director, Gun Owners Action League.
Yeah, a 6-hour episode of the Goal Podcast.
In the flesh, Oh, it's good having you down, man. Glad
I love coming down here. You guys are the best. I always have a good time on this show.
It's good time. Good time. Some of the topics are a little infuriating. But you gotta keep.
But that's why we're here.
Yeah,
that's the whole point. We wouldn't exist if everything was sunshine and rainbows and 12 gauges and there
has to be a song there. All right.
All right, that's it for today. Thanks for listening in. If you haven't already, be sure to subscribe to the show, share it with friends, and check us out on Facebook at facebook.com/Goal Podcast MA, on YouTube at The Goal Podcast, or on Twitter at Goal Update.
To join Goal, visit goal.org and click the Join or Renew button at the top of the homepage.
If you have a topic you think we should cover, if there's something going on in your club or town, if you have a question for the mailbag, shoot us an email, goalpodcast@goal.org.
The Goal Podcast is a production of Gun Owners Action League of Massachusetts. The views and opinions expressed are those of the host and guests. Mike.
This is my favorite part whenever me or Jim or John is on the show.
And do not necessarily reflect those of Goal, its staff, or affiliates. Says the staffer sitting in the room. Yeah.